historian? Well, for the reasons I've pointed out, the answer is no. At the very least, however, if judges allow themselves to use history, to use secondary histories to reach their legal conclusions, they should say why they have chosen particular historians over others and on what basis they have found one historical account to be more persuasive than another. If the reason is that the favoured historian has reached a conclusion that the judge had already reached, then the judge should ditch the history and get straight to the conclusion. If the reason is that the judge has read and compared all the alternative historical accounts and has been persuaded by the scholarship and the thoroughness and the mastery, etc., of one over others, that's certainly better, but still the objection follows. The historian should not be settling legal questions. So what's my conclusion? History should be used only very rarely, if at all. Now, I say rarely rather than never, because I'm thinking of one particular Australian constitutional case where history was finally the only way to settle a long-running dispute about the meaning of a particular provision. The provision, section 92 of the Australian Constitution, says that after the Federation of the Australian States, which happened in 1901, trade, commerce and intercourse among the states shall be absolutely free. It's essentially the Australian written version of the Dormant Commerce Clause. But what did absolutely free mean? So for close to a century, again and again, the High Court scratched its head over this question. It was the most litigated section of the Constitution. Absolutely free couldn't possibly have meant literally what it said, that there should be no regulation of any sort of trade and commerce. But did it mean that there should be no national economic regulation, or that Australia had to have a free market economy, or that individual traders whose businesses crossed state borders had a right to trade without restrictions on their interstate business? All of these accounts, all of these alternatives were tried out at one time or another. And the fact was that there was simply no legal answer to the question, and nor was there stable precedent. Absolutely free is not a legal expression. So finally, the High Court in 1988 decided to look at historians' accounts and to find out what we would now call the original public meaning of the provision. The court, in a very rare case of unanimity, the unanimous court was persuaded that it meant nothing more than that no state could impose upon the trade or commerce of another state or states a discriminatory burden of a protectionist kind. A state could, it turned out, because the case concerned the importation of undersized crayfish from